Hello, everyone. This is Tom Fox back for another episode. I'm thrilled to have back with me Kevin Carroll. Kevin, first of all, welcome back.
Thanks so much for having me on, Tom. It's always a pleasure.
Kevin, I'm not sure if it's every day we have an announcement about one of the Trump trials or maybe more than one time a day, but we had a fairly significant announcement earlier this week, which was Jack Smith filed a superseding indictment in the January 6th case in Washington, D.C. And so I wanted to explore that with you today. And I want to start by asking, could you explain to our civil side listeners what a superseding indictment is?
Sure thing. So a superseding indictment is just a subsequent indictment. You go to a different set of grand jurors and present, in this case, a different set of evidence. They took some of the evidence that had been presented to the first grand jury out in response to the Supreme Court opinion about official acts. And you get another indictment. Sometimes it adds charges. Sometimes it adds defendants. There was some thought here that charges were not added, additional charges were not added, that we might see additional defendants added. But here that wasn't the case. It was really just an exercise in deletion. They kept the same four counts, conspiracy and obstruction. They took out one of the unindicted co-conspirators, who's, if you read it, is understood to be former Assistant Attorney General Jeff Clark. Um, and they took out a lot of mentions of the president's discussions with the Justice Department for reasons we can talk about. And they emphasized when President Trump was having a conversation with Vice President Pence in what the special counsel termed as Pence's role as the president of the Senate, as opposed to the vice president of the United States.
We haven't had a chance to visit about the Supreme Court decision, so I don't know what quite your thoughts might be, but it was pretty clear that the Supreme Court granted blanket immunity for official acts for a president sitting in office. So I was not surprised and actually a little gratified to see all of the discussion around the conversations with the person you identified as Jeffrey Clark, who I think we all believe was Jeffrey Clark, and discussions with him as his role in the Department of Justice out. But there were some interesting, I thought, additions around those counts. And there were more additions around private side lawyers for the president. Could you maybe discuss those a little bit?
Yeah, exactly. They tended to emphasize more the Rudy Giuliani and the Sidney Powell aspects of it, precisely to avoid the official acts part of the Supreme Court decision. Reading the amended superseding indictment made me dislike the Supreme Court's decision in the case even more, because a lot of what they took out were conversations that Trump had with the Justice Department and that the Justice Department had with state law enforcement officials about bringing cases that they knew were not true. I mean, it's the worst kind of abuse of presidential authority to have the Department of Justice threaten an investigation or open an investigation on someone that they know is not guilty, or a case where they know there has not been wrongdoing. But under the terms of the Supreme Court decision, which I strongly disagree with, that is now immunized as an official act. It's just as bad, I think, as, or even worse, than ordering the Justice Department to let a guilty person go. I mean, here they're trying to create a criminal charge where they know one is not appropriate. And so Smith, with reluctance, I'm sure, took those facts out of the indictment. It's still a strong indictment. I think he still proves his cases of conspiracy and obstruction, but I think it shows the problems with the rationale of the majority of the court in Trump v. United States.
Kevin, could you explain the part you started to talk about around Trump's conversations with then Vice President Pence, but it was in Pence's role as the president of the Senate, and why that difference is important?
Yeah, I don't know if it's going to fly with the Supreme Court. That was one thing that sort of surprised me. The vice president, as we know, sometimes serves as president of the Senate in order to break a tie, for example, and also when counting electoral votes. And I guess what Smith is going to argue when this is inevitably comes up on appeal is that it's not an official act if the president is speaking to a member of the legislature, whereas it is an official act, perhaps, if he's speaking to a member of his administration. I'm not sure if that's really a distinction with a difference. I mean, the president could have taken criminality out of it. The president could certainly have an official conversation with the Senate about a treaty or with the House about an appropriations bill. So I'm not really sure that I would have cut it as finely as Jack Smith there.
The one of the things that the Supreme Court, I think, left us with is we're going to have a trial before a trial, I think. And many people had thought it could possibly happen for the election with a superseding indictment. I see no way for that to move forward. But could you explain the trial within a trial concept within the context of what the Supreme Court ruled?
I thought that was going to happen, and I was hoping it would happen just to give voters knowledge of what Smith has heard in the grand jury. Because, of course, appropriately, unless we're on the Justice Department team, we don't know what's been said in the grand jury. So it was looking quite possible that Judge Chutkin, the trial judge, would ask Jack Smith, the special counsel, to say, "Okay, counsel, what do you got?" And let's parse what kind of witness testimony or documentary testimony was produced to the grand jury that would be official or unofficial under the rationale of the Supreme Court. And Smith could have called witnesses to do that, or perhaps he would have given the court a proffer of what had been said in the grand jury. And that would have helped Judge Chutkin decide what charges and evidence could and could not stay. But as you said, being as they chose to go the route of the superseding indictment, I think the time is such. Early voting starts next week in my home state of Virginia, and the election is just over 2 months off. I don't see that they'd be ready for a large trial within a trial hearing before that.
Kevin, where do you see this case procedurally moving forward if there is a Democratic administration in 2025?
It'll certainly move forward, I think, if there's a Democratic administration, as is looking with today's polls increasingly likely. I'm not sure if you'll get interlocutory appeals. They had a very, but maybe you would. The reason they got the unusual interlocutory appeal was that the issue is immunity. And if you're immune, then having to go through the trial is itself a form of improper punishment. So maybe they'll seek interlocutory appeal yet again from the DC Circuit and the Supreme Court, saying, for example, that Smith is still discussing Trump's conversations with Pence, and those are official acts. And I guess that would maybe get him interlocutory appeal again. If not, the special counsel has had this case for quite some time. We're coming up on 4 years since the events. So you would think they'd be able to proceed to a trial sometime next year.
Where do you see the other trials that have at least gone forward? We're going to leave the Florida appeal perhaps to the side, but we have a potential sentencing in a state of New York case. We have a federal case, and I think we're to the collection part of that case, if that's memory serves. Where do you see the Supreme Court decision impacting either one of those cases?
As you said, setting aside the 11th Circuit matter for a moment, you have the sentencing coming up in New York, and I haven't practiced criminal law in the New York State courts. My understanding is there's really not a provision to get a matter before the appellate division or the Court of Appeals, which is the highest court in New York State, on a sentencing matter, for example. So I think there's going to be a sentence handed down in mid-September as is calendared. I think I'd be surprised if the judge remanded Trump into custody right away. I can see him, because we're getting so close to the election, perhaps suspending any custodial sentence until after the election or after the inauguration, or indeed until after Trump's second term, if it comes to it. I don't think the Supreme Court decisions impact the state judgments. You've got the state fraud judgments, which are all, as I understand it, regarding activity that took place, criminal activity, illegal activity, fraudulent activity that took place before Trump took the presidency. You do have the E. Carroll federal tort claims and the damages on those. The defamatory statements there, not only denying the rape, but rather calling E. Carroll a liar, bringing the charge of rape. Those are certainly during Trump's presidency, but it can't really be seen as official acts. I believe that the DOJ tried embarrassingly to argue that defaming a rape victim was somehow an official act of the president. And the SDNY, and I believe the Second Circuit, rejected that. The Georgia criminal case, the Georgia state criminal case, which is in disarray after the alleged misconduct of the district attorney and the special prosecutor down there, I think there will be appeals on that going forward in light of Trump v. United States, because it, again, goes to the exact same immunity issues and official acts issues that were raised in the appeal to federal DC case. And then, I mean, it's just amazing the amount of litigation the man has gone on. There's the Florida case, and we're waiting. Jack Smith has, of course, appealed the decision of the trial court that he is not properly serving as special counsel. Trump lawyers will respond to that. It'll go up to the 11th Circuit. I think certainly Judge Cannon's decision will be struck down. I think the question is whether or not the 11th Circuit moves sua sponte to remove her from the case, being as this will be the second time she's been reversed for really spurious decisions. I mean, the appearance that she's just acting entirely as a partisan actor to try to get the president who appointed her off is just overwhelming.
Kevin, I think I read this morning we're 77 days from the election. Would you anticipate much action or filings, rather, I suppose, in any of the cases other than the New York State court case in this interim period?
It's a great question because by the old Justice Department regulations, you're not supposed to take an investigative step that'll become public knowledge when we're this close to the election. And I always thought that made a lot of sense because it would not be fair out of the blue to say Governor X or Senator Y is under indictment for bribery, but we're not going to resolve it till after the election. You'd be sliming the guy or the gal, and maybe they're innocent. And so taking that sort of a first affirmative public step by unsealing an indictment, for example, arresting someone, would be improper. Here, the crimes, again, took place almost 4 years ago. There's been ongoing litigation in some cases for years over them. There are court deadlines to respond to. My guess is that DOJ will go forward with the regular briefing schedules and argue that these are not new investigative steps. They're just responding to decisions of the court by timelines often set forth by the court.
Well, Kevin, one thing I can be assured of that we will be discussing this at some point further, one way or the other.
Absolutely. And I really wish the court had come out differently on the official acts question. And I think we're going to see some of the ramifications of this. When I was a congressional staffer, when I was an administration political appointee, it was 100% understood by everybody that campaign activities are not official activities. That's why you were not allowed to make fundraising solicitation calls for your desk in a House office building. It's why you were not allowed to send emails back and forth to the campaign from your seat in a cabinet building and your executive branch email. Everybody knew the rules. If it has to do with the campaign, it's not an official act. It's a political act to get yourself elected or reelected. And I don't understand how the Supreme Court allows this up so badly, saying that something can be an official act regarding the reelection campaign.
Kevin, I wanted to thank you again for taking the time to visit with me, and I look forward to continuing this conversation.
Right back at you, Tom.